Good morning. I'm John Bitson, the Menard Family Director of the Sheila and Robert Challey Institute for Global Innovation and Growth. Welcome to the Human Progress and Flourishing Workshop. This is our last of the 2024 year, but please be ready. We're going to make an announcement soon for our spring series, so we'll have 6 more in the spring. They'll focus on issues ranging from healthcare to looking at workforce issues to looking at land use and housing policy. So I think it's going to be a great series in the spring as well. I'm really excited about today. We have one of our own here today, one of our own NDSU professors and also a Challey Institute senior fellow, Jeremy Straub. I'm excited. He's going to talk about AI policy. He's very knowledgeable about artificial intelligence and cybersecurity. So if you have been hacked recently and want free consulting, Jeremy said, you can come and talk to him. He didn't really say that, but I'm sure he'd be willing to help you. So Jeremy Straub is a senior faculty fellow at the Challey Institute for Global Innovation and Growth and an associate professor of computer science at North Dakota State University. His research focuses on the intersections between technology and policy in both artificial intelligence and cybersecurity areas. He is a lead inventor on 2 U.S. patents and has published over 50 journal articles and hundreds of conference papers. He is a member of multiple professional societies, including the American Society for Engineering Education and SPIE. His work has been supported by the National Science Foundation, the National Security Agency, and the National Aeronautics and Space Administration, and other sources. He is the director of the Institute for Cybersecurity Education and Research. Let's all give a warm welcome to Dr. Jeremy Straub.
Thanks, John. And Tate, I'll get the billing codes from you later for all the services John just gave away. This could get to be very expensive. What we're going to be talking about here today is artificial intelligence policy. And if I asked this question a year ago, or if I started this presentation a year ago or 2 years ago, I probably would have started by asking kind of what people's backgrounds was with AI, what people were aware of. I'm going to change it to a slightly different and maybe more specific question, which would have cut through maybe about 3 or 4 questions. I would have asked, how many people have heard of a large language model in here? It's a pretty specific question. All right, so it's almost everybody. There may be a few people that are just deciding not to raise their hands because that's what people do when it's an early morning on a Friday, a week or 2 before finals week. But again, I think we've gotten to the point now where almost everybody is somewhat aware of artificial intelligence. And now we go from the exciting period of developing the technology to the point where it's ready to enter the mainstream to it really having entered the mainstream and figuring out what to do with it. And that's where policy comes in. And so I think just as kind of a preface to this, it's also important to understand that we've all heard about, LLMs, ChatGPT, Meta's Llama, all of these different things recently, but AI actually has been around for quite a while, and you've probably been using it without realizing that you were prior to starting your subscription to ChatGPT or another online service. Everything from those annoying phone messages or phone systems where you listen to the messages and you used to have to press a button. Now it does voice recognition. That voice recognition, for example, is an example of AI. Even adaptive routing, figuring out where your call should go based upon things that you've said, as opposed to just, pushing the number 4 to choose a particular menu. That's another different example of AI. So if you think about some of these uses, you probably have been using AI a little bit longer than a lot of people have been kind of super aware of it. And that's okay, right? But now we're getting to the point where AI is kind of everywhere and it's something that's beginning to affect everyone. And when you get to that point, you really have to start thinking about the policy implications and how you actually control this type of a technology and to the extent to which you should, right? I mean, there's nothing that says we necessarily need to control everything with policy, but that's the question that we're asking when we're thinking about the policy implications of a technology. So today I'm going to kind of go through 3 very highly related areas. I'm going to talk just a little bit about the areas that people can regulate AI in. It's not to say that we necessarily should have regulations in these areas, but these are the areas that we hear about a lot when we're thinking about AI and regulation. I'm then going to talk a little bit about regulation at the federal level, and then finally finish up with regulation at the state and to a lesser extent local level. So that's kind of what's in store. Thanks everybody for joining, and we'll go ahead and just continue to charge on here. So you can see on the screen here 8 different areas of regulation. I'm going to spend a minute or two on each of them. Hopefully some of these are areas you've maybe already heard about: privacy, anti-discrimination, protecting human jobs, preventing human harm, regulating the technology itself, educational considerations, national security considerations, and then of course fostering the growth of the technology. And again, we'll spend just a second on each of these. So the first thing that we have here, again from the list, first thing we have here on this slide is privacy. This is one that we've heard a lot about. So we've heard about how different uses of systems could, for example, take one person's information and inadvertently give it to another if the model did something called learning that information, and then something else called regurgitating that information. Exactly how that happens is kind of a highly technical thing that we're not going to get into today, but suffice it to say, with certain technologies, not with all, but with certain technologies, there's the potential that the underlying mechanisms of the technology can potentially embody information that's supplied to it by a user, and then when another user makes a query, they can inadvertently reply with that information. And the challenge here is from the perspective of a large language model, your data really isn't that different than any other data that it's exposed to, right? It doesn't really know that this is your address as opposed to, say, the address of a hotel or the address of an office building, or your name as opposed to the name of a historical figure, or the combination of multiple different details that may relate to you as opposed to details that may be unrelated. It also doesn't understand how certain pieces of information are maybe more sensitive than other pieces of information. And it's not to say that we can't create systems or mechanisms or even prompts that help AI technologies understand these things and make good decisions. But from an individual's perspective, there is more of an absolute expectation of privacy. Not that it works most times, but that it works all of the time. The fact that the system didn't regurgitate your information 99 times out of 100 is not the thing that people are going to remember when it does on that 100th time. People are going to be upset about the time that it failed and provided people's personal information to whomever may be accessing it. And if you think about the types of information that electronic systems store for individuals, it's really quite amazing. I mean, most people's lives, most facets, maybe all facets of their lives are now in some sort of electronic system, whether it's your computer, your cell phone, an online service, photo sharing services, social media. The amount of information that's out there either on your personal devices or in the cloud is quite staggering. And not only does that create the issue of, okay, well, what if this piece of information or that piece of information or another piece of information gets disclosed? You get to the question of, well, what if pieces of information from different places get pulled together and get disclosed all at once? Your personal chat with a friend gets combined with your workplace, document, and suddenly now the client that you thought you were going to be winning for your company is instead getting, random messages you post on social media when you were 16 that maybe weren't in the best of taste. So there's a lot of challenges here. And that's one of the things that we're thinking about when we're talking privacy. Anti-discrimination is another really important area. And this is not, again, just like privacy, it's not unique to AI. The concern is when we have an AI system that may not understand the difference between certain things, the difference, like I said, between your data and somebody, and data that may be not sensitive. It may not understand what it's doing when it discriminates. It may not know that it's discriminating. It may not know why it shouldn't discriminate. And those, again, are things that we need to make sure that the technology does, that it's preventing the discrimination and that it's not discriminating. So again, there's a variety of different ways of doing it, but when we get into the anti-discrimination regulation, there's already a lot of regulation here. We're going to talk a little bit more about this area in detail. But again, this is another important area. It's another important consideration for AI systems. The next area on the list here is human job protection. Now, this is a more interesting area. And so, if you look back at technologies kind of through time, there have been many, many, many cases of people saying this new technology is going to eliminate the need for human workers for whatever reason. So how many people have heard of the cotton gin? Anybody? Cotton gin? Okay, about as many people as have heard of AI. That's interesting. Or maybe we have a group that just likes raising their hands. So the cotton gin was a very early technology in the the industrial revolution, which was the introduction of a lot of mechanical devices. And so when the cotton gin was introduced, it took the labor of numerous people in a field, and this was work that was very difficult, right? This was work that took a lot of effort. It was very tiring. You know, the type of work that for a lot of people is the type of stuff it would be nice to automate because you don't necessarily really want to do it. And it took multiple people, and it turned it down into basically one person operating this device called the cotton gin. And of course, there were newspaper articles at the time that said, well, this is going to put tons and tons and tons of people out of work. And of course, it didn't, right? If you look at our unemployment statistics right now, despite decades and decades and decades of the cotton gin being in existence, we're still hovering in single-digit unemployment numbers. It's not like a third of the population that's out of work, and also the number of people working on farms has fallen dramatically within that time period as farmers have been able to bring in better and better technologies to further automate this area. And North Dakota and Fargo is really an industrial hub for the development of these technologies, with Bobcat and John Deere and others right here within miles of us. These are technologies that are not only benefiting people around this area, but they're also being developed really nearby, which is interesting because it may be a model for the development of AI and the use of AI regionally as well. But suffice it to say, without going too much further into the history of this, like every technology before it, there's a concern that AI is going to replace certain types of jobs. And where this gets maybe a little bit different than some of the previous concerns is that the jobs that are being contemplated as being potentially replaced by AI are not jobs that are necessarily highly manual labor. They're jobs like doctors and lawyers and other roles that again are for a lot of people aspirational jobs as opposed to jobs that might be something that you work. And of course some people very much love doing jobs that are that have a physical component to it. But for a lot of people, those are jobs that you might work until you're able to find a different job or a better job or a job that's not as taxing, particularly as one ages and may not be able to do that same level of physical work that they might have been able to do at a younger age. So again, that's where a lot of the concern comes to from the AI perspective on human job protection, again, that it's potentially going to displace some of these high-paid and for many aspirational type jobs. The next area that we have here is preventing human harm. And this is an important concept, right? I mean, we want to prevent harm to humans. That's very foundational within our society. It makes a lot of sense. Of course, we don't want people being needlessly injured or coming up to other types of harm. The challenge that we get into here is defining what a human harm is for the purpose of regulation. There are lots of things that we all do that are potentially harmful that we accept a certain amount of risk. If anybody's ever gone rollerblading or ridden a skateboard or driven when it was perhaps not ideal weather outside, these all have elements of risk that you assume where you're saying, well, I want to do this activity, so I'm going to be slightly less safe, maybe somewhat less safe than if I was just sitting in a building not doing these particular activities. And so you get into this question of, well, where do we draw the line? Where do we say this is a harm that we want to prevent versus a harm that is acceptable or that is up to an individual to assume the risk or not of? Again, that's the kind of crux of that area. Our next area, again here, and going through these kind of quickly just to give you the playing field before we get to kind of what the regulation process and some of the particulars about it looks like, is an important one. And this is the regulation of technology. So technology regulation is kind of a catch-all for things that in some way seek to regulate the technology itself, any technology, as opposed to its use. So for example, if we say, well, you can't use an AI technology to process applications for a job in a way that might discriminate based upon a protected characteristic, that is an application, right? That's talking about a technology and its specific use for something. We can regulate just the application, we can regulate the technology as it's used in that application, or we can potentially just try to regulate the technology. So This category here is when we're just talking about regulating the technology, when we're saying that something like, again, a large language model or other AI system can only be used in a certain way or can't be used in a certain way for whatever reason. So again, there's a lot of different considerations with that, but again, what we're talking about in this category is the regulation of technology itself. The last area on this slide is education. This is an area that encompasses laws that are used to change how AI is used in education, to maybe cause people to get education about AI, to change the different ways that people are exposed to AI. Again, it's kind of a broad catch-all category that covers everything that relates to AI as it interconnects with education. Our last two areas are also quite broad. The first is national security. So national security is, again, a broad category of regulation that discusses things like how AI might be used by the military, by intelligence services, and others that have a role in the national, in the preservation and promotion of national security. And this gets very challenging because there's a lot of different questions that you come to when you start thinking about any technology as it relates to national security. Of course, these are regulations that can promote growth and use. For example, we have executive orders and agency rulemakings right now that are saying that each agency should be looking to see how they can make use of AI subject to certain guidelines and principles. These types of regulations can also restrict certain activities. So again, I just said, let's use AI in each agency, but again, that's subject to certain guidelines and principles. Those are the restrictions. We're going to use AI to make targeting decisions, but we're not going to let an AI actually press the proverbial button that fires the weapon. That's a restriction on the use of a particular technology. And again, there's a lot of opportunity here to think about and to discuss what's appropriate under certain circumstances, and that's where, again, the process of regulation comes in. The last area here, the last bullet point, is thinking about the use or the restriction of uses in domestic applications. That means applications within the country that is using or considering using a technology for national security purposes. So for example, in the United States, we have certain agencies that are allowed to do things outside the United States that they are not allowed to do within the United States. So for example, there are certain types of surveillance activities that can be conducted by intelligence agencies that cannot be conducted domestically by those agencies, meaning within the United States, and are somewhat restricted in terms of actually conducting those activities on Americans, even if they're outside the United States, if the agency recognizes that they are actually targeting a US citizen. So that's another example of how we may see regulation in the national security space. Again, all of these things, and that's really the key with all of these topics we're discussing right now, all of these things are kind of the maelstrom of consideration that has to be thought of as we're considering regulations at different levels. So our last area is perhaps the one that is, I would say, maybe the most important. I mean, it's difficult to say because it's important to say what we shouldn't do. It's important to say, let's make sure we don't have bad things happen. But we also want to focus on doing good things too, right? We want to focus on actually growing technologies, growing their use, and using them to provide benefits like increasing human prosperity, encouraging human flourishing. And so how do we do that with AI technologies? Well, the first thing is, of course, we have to develop the technology. The second thing is we have to have policies in place that promote its use in certain environments, and certainly removing or preventing the development of regulations that impede the ability to use them in ways that are beneficial to humans is another kind of key area. So that's the end of the kind of crazy background. I hope everybody has enjoyed thinking for a moment about those different areas. Again, we'll have some of those kind of come back as we discuss kind of what this means in terms of regulation at the federal and state and to a lesser extent local areas. But those are the kind of key areas we're going to be thinking about as we charge forward. So we turn now to federal regulation. These are regulations that are created by, say, for example, the United States Congress, signed into law by the president, There also are things that are called executive orders that are issued by the president that control how agencies act, what agencies do and don't do. We also have regulation that is created directly by agencies themselves through rulemaking processes. There's a lot of different ways of getting to federal regulations. The last thing that really isn't a federal regulation per se, but sometimes can have a very similar effect, is judicial decisions, where the court interprets what might be a very vague or some may think is an applicable law, some might think is a law that applies in a certain way. The court determines how it applies. And in some cases, some people that don't, usually those that don't like what the court decided, may argue that the court is doing what's called, quote unquote, legislating from the bench referring to where the judge is sitting. That's a classical term that's used to refer to the seat of the judge. Again, there's a lot of different sources for federal regulation, and there's a lot of different processes. We also have existing frameworks that federal regulations fall within, and we'll talk about those a little bit more in a second here. The important thing to understand here, and really if you take nothing else away from this presentation, take this, is that we already have a lot of laws that relate to AI. So we've heard an awful lot of, well, we need a law to regulate AI in this area. In most cases, if you already have a regulation in the area that says, we should do this or not do that, and that's what you want to do or not do, that law already regulates AI. So I'm going to look at one example here. This is the Civil Rights Act of 1964. This is an incredibly important piece of legislation, and again, we're not going to get into the details of the Civil Rights Act itself, but again, it was a very early law that started actually changing, making a lot of the changes that we now all take for granted in this country. Again, very important law. But what's really interesting about it is looking at these two sections that I've called out. So section 601, no person in the United States shall, on the ground of race, color, or national origin, be subjected to discrimination under any program or activity receiving federal financial assistance. This applies to everything from support for your college educations to federal funding for different programs that you may participate in the community, federal housing programs, etc. This is very broad language that is very impactful because the federal government actually funds quite a lot. And it's not just to the extent that the federal government is funding a piece of it, right? If the program is benefiting from federal funding, the program has to abide by this fully. The other section here relates to employment discrimination. It shall be an unlawful employment practice for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. Again, this is the foundational law that prevents most types of employment discrimination, at least those that are based upon those characteristics that were enumerated in the law. What's really important about both of these is it doesn't say this discrimination is only prohibited if it's done by a human. It says that the discrimination is prohibited. So it doesn't matter whether it's a human making the decision, an AI, another electronic system. If you're taking and flipping a coin to make the decision and you're discriminating, it's prohibited by this law, which means that if this law is doing what you need, if this law covers the area that you're concerned about, you don't need necessarily another law that specifically covers AI regulation. And this is a really important concept in trying to figure out what needs new AI-specific regulations and what doesn't. So this is not to say that there's no need at all for AI-specific laws. In fact, there may be some laws that are not as well written as the Civil Rights Act that, say no person shall do this or no person shall do that. In a lot of cases, laws don't have that specificity to them because they've already been broadened to include preventing activities, say, by corporations or other circumstances that make it so you're not just contemplating the actions of a physical human person. However, this is not to say that there are not some that exist. And in the case where something that you don't want an AI to do or something that you do want an AI to do is referred to in an existing law as relating only to a physical person, or where you have an enumeration of, like, say, a physical person, what's called a juristic person, which means basically like a company formed an entity formed by a process such as a company. If you have things that refer specifically to those and enumerate them as opposed to the broad language of no person shall be discriminated against that we saw in the Civil Rights Act, those are types of laws you may need to change. And in many cases, not all, but many, the solution may be to simply broaden the language so that they cover, more broadly, prescribing or promoting the activities that you wish to prescribe or promote. One benefit to broad language is that you don't have to keep going back and changing it, right? So if we wrote a really specific law today saying we don't want a large language model to do X, in certain circumstance Y as it relates to person Z, this law would cover that. It would cover it quite specifically. It would be very easy for courts to interpret compared to some of our more vague laws. The problem is, well, what do you have to do if you're an entity that doesn't want to follow this regulation? Well, the first thing would be, well, you don't use a large language model. You use a moderate-sized language model. How you define that is anybody's guess. But it turns out when you make laws really specific, they become relatively easy to work around. So there are benefits in some cases to having very broad laws. There are also downsides, and certainly one of those downsides is if you make laws broad and vague, they also become more difficult for courts to interpret, and you may end up with courts interpreting them in a different way than perhaps the people that wrote the law initially anticipated. Also, over time, the interpretation of the courts may change, and you can still have circumstances where you write a very broad law, and then circumstances or technology or other things change, and the law is still not applying in the way that might be ideal or desirable. Another thing that we want to think about when we're making federal regulations is where to put them. There have been a number of discussions about making like an AI law, a big law that covers many, many, many uses of AI. And I would recommend not doing this. And there's a really simple reason for this, which is it just becomes very difficult to find the relevant sections and maintain. So we already have lots and lots and lots of laws that relate to different topics. If we put the AI topic, if we say, well, we have our non-discrimination law over here, but we're going to have our AI shouldn't discriminate law over there, what can happen really easily is somebody updates one and they forget to update the other. Now, this isn't to say when Congress passes a law, they can modify numerous sections of the United States Code at the same time. This isn't to say that we couldn't have a particular bill that modifies multiple portions of USC, but that when we are making those modifications, we want to try to put stuff that relates to regulating AI specifically really close to regulating those activities, whether it uses AI or not. Again, and there's other examples of this, right? There are examples in the United States codes and other regulations of things where you have a broad regulation and then you have more specific things where it says, okay, well, broadly, you shouldn't do this. More specifically, you shouldn't do this in this particular circumstance. Or here's an exception to this broad regulation that relates to a particular circumstance. Again, putting things nearby makes a lot of sense. The same thing is true with the Code of Federal Regulations, which is the area of federal law that is promulgated by agencies using a rulemaking process. One of the challenges that you have with CFR is that while Congress can modify any area of the United States Code, agencies have specific areas of CFR that they're responsible for. And so you can have an agency that's making a rule in one area, modifying their own area of CFR, that doesn't have the ability to modify another area, which can cause fragmentation of where different types of laws are located in. The other thing that gets kind of tricky with CFR is that you also have to look at whether Congress has empowered the agency to make a particular type of rule. And so we've seen recently with the Federal Trade Commission beginning to take a number of regulatory type actions, pushback from some of the people that are being targeted by those, arguing that Congress didn't provide the Federal Trade Commission with the actual power that they're wielding at the moment. And so that's another thing that you get into when you're dealing with CFR, particularly if an agency is trying to regulate beyond their bounds or beyond the bounds that they've typically regulated in and that people have kind of come to accept that they regulate within. Let's go ahead and keep charging on here though. What I want to talk about is a few areas of potential federal laws that might be beneficial as well. So one area that has been mentioned by a lot of different people as being potentially beneficial, and it's pretty obvious as to why, is laws that prevent numerous conflicting state and local AI regulations. And there's an important concept here. We'll talk a little bit more about this in a moment. I've already mentioned this once or twice, which is federal preemption doctrine. This is a concept that means that federal laws generally take precedence over state and local laws. It's a little bit more complicated than that because the federal government in the United States is not a government of unlimited power. It's a government of constrained power based upon the US Constitution. So a federal law that is not within the realm of the federal government to regulate may have no effect and thus may not preempt a state or local law. But within the realm of where the federal government can regulate, a federal law takes predominance, takes precedence over a state or local law, which means if you're a company that's operating, say, in all 50 states and hundreds and hundreds and hundreds of cities, as opposed to having to have a special version of your system for each of those localities to deal with some special local or regional law, you can have one system that's used everywhere. And so, imagine if, like a social media company had to have a different version of their website for every city that they operate in because that city had a regulation about how social media could be used or when it could be used or how identities were verified or something else, right? It would be unwieldy, and what would happen is that people in the biggest cities would have access, right? It's really easy when you have a city like New York that has 8 million people in it, which is, more than 8 times the number of people that live in the state of North Dakota. They're going to probably get a customized version of the technology, whereas somebody that's living in a small city that has 20 people in it, if they have a regulation that prevents or is seen to perhaps prevent or impact the use of a technology, they might just be simply out of luck. They may not have access to it. And so again, there's a real benefit to having, as it's possible, as it's within the federal authority to do, regulations that lay kind of a groundwork for AI use at the federal level. We can all discuss what those should be, what we should allow, what we shouldn't allow. But again, there's a lot of benefit to having at least a foundational approach at the federal level that prevents lots and lots and lots of potentially conflicting state and local regulations. One of the things that we can do at the federal level is protecting AI development. So I've mentioned earlier that you can regulate a technology, you can regulate a technology as it relates to a certain application, or you can regulate an application. In many cases, regulating a technology doesn't make sense. The first reason why is that technologies change. Technologies typically change much faster than people can regulate them, and usually regulation is responsive, not forward-looking. And so if you tried to regulate today's technologies, but those regulations are still hanging around tomorrow, it's possible, again, that they have an unanticipated effect, that they're blocking a desirable use or just simply making things more difficult. Another thing that can happen is that the regulation becomes confusing when it's not clear exactly how a particular regulation that was written for an older technology or an older version of a technology applies to a newer technology or a newer version of a technology. So typically, regulation of the application of a technology makes a lot more sense than the regulation of a technology itself. The other problem that you have when you're regulating technologies is that regulation inhibits growth. So Bill Gates really famously said that his biggest concern throughout certain points of the development of Microsoft was that 2 guys in a garage were going to come up with something better, that they would overtake what Microsoft was doing. Obviously, there have been lots of competitors to Microsoft. Microsoft is still around, so those guys in the garage weren't as successful as Bill Gates perhaps was concerned. However, when you start making lots of regulations that relate to the development of the technology, the first people that are impacted negatively are those people in the garage, the people that don't have an extensive legal team, that the first time they get a letter from wherever saying, you can't do this, this is prescribed, you're going to get in trouble for this, their solution is simply to stop because they just don't have the financial wherewithal or the legal wherewithal perhaps to know how to deal with that. Big company gets a letter like that, they may fire their own even more snarky letter right back, right? They'll say, well, no, we're allowed to do this because of this and this and this and this. You sue us, we'll sue you right back, and we have more lawyers. But again, it can be very, very negative for small businesses and even pre-business formation groups. So we want to typically try to avoid regulating technology development as much as possible for this very reason. An additional wrinkle from a regulatory perspective in regulating AI is free speech considerations. So AI is software. It is a form of expression, and we have a hopefully very well known to the folks in this room, legal framework in this country that doesn't allow us to fully regulate in almost all cases, and in some cases prevents almost all regulation of forms of expression. This legal framework comes from the First Amendment to the Constitution, an area commonly known as the Bill of Rights. And when you start trying to regulate the output of an AI system, when you start trying to regulate the typing of code on a keyboard that produces an AI system, you are inherently regulating expression. Now, where this gets tricky is that this prohibition, despite how clear the Constitution sounds when one reads it, the courts have interpreted away portions of that clarity over time. We know that the courts have interpreted certain types of communication as less protected, less unable to regulate than others. So what we haven't seen yet is a whole lot of judicial decisions looking at how software and AI systems outputs, communications, et cetera, how these are going to be regulated in terms of expression, in terms of the protections provided by the First Amendment. And those are going to be some really interesting cases when they happen, because they're going to really go, potentially right back to constitutional doctrine as it relates to a technology developed, so far after the creation of the Constitution that it's very difficult to make an argument that the Founding Fathers foresaw how their particular Bill of Rights, their amendments would apply to this particular technology. It's so different from what was available at that time that it becomes particularly interesting. The last area on this slide is laws or agency regulations that codify copyright and patent protections of AI-generated and AI-developed content. Another big area of challenge that we have right now is that we have two agencies, the Copyright Office and the Patent and Trademark Office, that are coming up with their own policies and procedures regarding how AI-generated work should be treated under their processes. And it's very interesting. Again, we don't have a whole lot of time to get into this today, but it's very interesting to look at some of the factors that they've taken into account when they're thinking of, well, how much human content does there need to be for it to qualify for copyright? How much human content does there need to be for something to qualify to be patented? And the challenge here, I think, is that eventually we're going to get to a point where AI-generated content is both copyrightable and patentable, just because of the significant level of benefit that these technologies provide. However, it would be nice if we got there, in my view, faster, because I think right now what we're doing is creating a lot of uncertainty where we're probably going to have some legal challenges to things that probably should be copywritten and should be patented by argument of the fact that there wasn't enough human involvement or that particular areas didn't have human involvement. And again, we have lots of other technologies that have been used in the creation of of copywritten works and in the creation of patentable technologies. And obviously the way that AI is used is different than some of these other prior technologies. However, it would be kind of like saying, well, we can't copyright this presentation here today because of the microphone, right? I mean, the microphone is providing an important service from the perspective of a recording. If I turn this microphone off, you're going to be losing a lot of content. That doesn't mean that copyright shouldn't attach. Again, AI is different, but there's already a lot of kind of suggestions that technology involved in the development of something probably shouldn't change its perspective under copyright and patent tremendously. However, we're not there yet nationally. We're not there yet from a regulatory perspective. And this is a really important area, not quite as, something that's not quite as, doesn't have quite the same level of awareness of the public as some of the other areas that I've discussed, but actually it can be very impactful because it relates to how people are developing content, how people are developing technology, and intellectual property rights that we all, to some extent, rely upon to protect, even our most basic work. So I now want to change focus to talking about state regulations. Oh. All right, looks like, sorry, the two screens are not synced, and they got out of sync there for a second because that one, the one that you guys are looking at, didn't advance when I tried to advance the other one. What I was saying is I now want to change focus to talking about state level regulations. And we come back to something that I mentioned earlier, which is this concept of preemption doctrine. So it's a little bit more complicated than what I have here on the slide, but when you're making state regulations, you want to be thinking, or local regulations, you want to be thinking about preemption, because what you don't want to be doing is making regulations that have no ability to take effect. It doesn't matter whether you like the regulation or you hate the regulation. If the regulation is preempted, it's pointless, right? Because it will be overridden by the higher level regulation. So a very kind of rough notion of preemption is this. We start with the federal Constitution. If the federal Constitution speaks directly to something, that's the last word on it. You can have other things that interpret it, that talk about the logistics of how to do it, etc. But the federal Constitution, if it answers something, that's where you stop. We then get into federal treaties. It turns out the Constitution has language in it that says that federal treaties are the supreme law of the land. That is I think a pretty close to direct quote from the Constitution. I may be off there by a word or so. Suffice it to say, if something is embodied in a treaty that is ratified and in effect, it has at least similar effect to federal law, and probably an effect that slightly overpowers federal law on the same subject. The next area that we talk about is federal law. These are the things like in the United States Code, et cetera. And then finally, we get to state constitutions, state laws, and other regulations. Again, if you have something in your state constitution that speaks directly to something, topic, you can't regulate that in a way that's inconsistent with the state constitution. So again, these are important concepts. I mentioned earlier that there's a big caveat to this, which is that the federal government has limited powers. If federal regulations go beyond the powers that are granted to the government in the Constitution, then the state law may have precedence over that because the federal law has no effect. So again, this is very complicated. This is something that's very expensive lawyers argue about in front of the Supreme Court with a certain level of frequency. But it is something that's important to just have in the back of your mind as you're thinking about regulation, is that in some cases you may have a federal law and it may still make sense to make a state or local law if you think that the federal law goes beyond the bounds of what the federal government's allowed to do. When we start thinking about state laws, there's a lot of things you can do with state laws. You can create an enabling effect for technology. You can create a conducive environment for AI developers. And this is the interesting one. You can potentially combat laws from other jurisdictions that have extraterritorial effect. If the next state over tries to pass a law saying you can't do this in your state, a really good way to give protection to entities that you might want to be able to do this in your state is to create a law that says, yes, you can, or even better, a law that says you have to. Because now the entity can say, well, I'm being told I can't and I must. I can't do both of those. That inherently becomes a question that a court has to solve, because you can't tell somebody, you're going to get in trouble if you do this. You're also going to get in trouble if you don't do this. We have certain expectations of how laws work together. I've already mentioned a few of the things on this slide, so I won't spend a whole lot of time on it. In terms of just final thoughts, in terms of some good practices, we want to try to regulate, I think, technology or uses, not technologies. Again, technologies change. Uses are typically where we are dealing with the most impact. So when we're focusing on creating regulations, we want to typically focus on regulating use and not technology. Again, technologies change. Uses perhaps are more durable in terms of what needs to be regulated. We want to assess existing regulations. If there's an existing law, it's probably better to alter the existing law, adding to it, changing it, et cetera, as opposed to making new laws in a particular area. And it's important to protect technology development. Again, our national competitiveness in a lot of ways, I think, comes down to our success in maintaining what lead we have and continuing to build AI technologies into the future. And so regulations that have the effect of making it more difficult, making it more expensive, making it more confusing to create technologies are typically not going to be conducive with these types of goals of promoting national growth of the technology. A few kind of key thoughts here. Narrowly targeting to prevent specific harms is a good practice. Again, I talked a lot about broad regulation, but when we're talking about specific harms, we should try to be very specific about how we define those specific harms, because again, if you prohibit harms too generally, you kind of get into the question of what's a harm, what should be an individual's ability to say yes or no to, versus something that is being decided for them by laws. Another good thing to think about is sunset provisions, things that make a law or portions of a law have to be reviewed to have continued effect. This prevents laws from getting on the books and then never being able to be removed because they just don't make it back up to that level of importance that they did that got the law passed initially. So having something that says this law goes away or this law, acts in a different way if it hasn't been reviewed can be very helpful, either to forcing the process of a law being reviewed because people that are interested in the existing regulation will bring it back up, or providing an opportunity where it's, we need to go back and we need to revisit this and we need to see if this did what we think, if it worked well, and make decisions with now a little bit of knowledge about how the law works. And finally here, we want to consider constitutionality and the preemption of laws. It really doesn't make a whole lot of sense for bodies to be creating laws that are likely to be struck down. It creates a lot of uncertainty and really is not very respectful to the populations that are being regulated to be creating laws that are likely not to be upheld. So again, it's very important, I think, to be looking at these questions of constitutionality and preemption. Not that there's always going to be a perfect answer to them, but certainly it's good to be thinking about it. With that, I come to a close. I think we still have a few minutes for some questions, but thanks everybody for listening, and happy to take your questions. Any questions?
So when you have laws that you're talking about advocating for the laws that prevent misuse of the technology. Mm-hmm. So are there complications with figuring out who broke the law in some cases?
So yeah, that's a good question. I mean, so the question was, are there complications of figuring out who actually was the person that broke the law when you have a law against the misuse of a technology? And the scenario that you might have here is where you have a company that, say, develops an AI system or even develops an AI system for particular use, and then a company who actually uses it, perhaps not realizing that it acted in a certain way, or even that it failed in a certain way. So you could have a system that works in most cases, but doesn't work in a specific case that actually runs afoul of a certain law. And certainly anti-discrimination laws are a really good example of a case where something like this could go wrong, where perhaps due to a bias that is built into a lower level component of a system, perhaps due to a bias that comes into the system by recognizing how the system or how the humans are making decisions over time, and the system does what it's basically seen the humans do. It replicates the humans exactly, but it also replicates that bias. You could have questions of, well, who's responsible for that conduct? And so I think that is an important question. That's certainly something where a combination of regulation by Congress, regulation by state and local entities, as well as court decisions are going to have a lot of work to figure out kind of who's responsible for what. And it's certainly something that's really good to be thinking about. The way the regulations are written right now in a lot of areas, it puts the impetus primarily on the user of the system. If as a company, for example, you're not allowed to discriminate based upon certain protected characteristics, if you do that, it doesn't really matter so much how you got to that point. Now, you may have a discussion about how much, how wrong the entity is, how much damages should be assigned, where the fact that the entity maybe didn't realize they were doing it, or there were other mitigating factors, may reduce the punishment for those bad acts. But again, that impetus is normally on the entity that's using it. And you get into some challenges there as well, where particularly if an entity is using a system that's designed to do a certain thing and it's doing that in a way that is breaking a law, it's probably not fair for an entity that on good faith bought a system to comply and it's not compliant to be solely responsible. And so we have this really great question, this really important question of where do you assign the responsibility from both a criminal and a civil perspective when you're in that kind of case. So that's a great question, John. Thanks. Any other questions? Yeah, on the lower level first.
So my question is embedded in 3-1. The first one has to do with how do government agencies regulate AI use and compare it to other countries? How is the US government going to regulate AI as compared to other countries like China? And I bring on board a classic example of TikTok, where at a point the government wanted to ban it because it was exposing some information. So that's my question. How does AI use is regulated in the United States as compared to countries like China?
No, so that's a great question. How AI is currently, and I guess probably is going to be regulated in the United States as it relates to other countries. Certainly, I think each country has its own rulemaking process, its own ability for people to be involved to a lesser or greater extent. And there's a lot of opportunity in the United States for people that have specific concerns or specific ways they would like AI to be regulated or not regulated to get involved. That's certainly not something that's true to the same level in other countries. Unfortunately, I think this is a very broad question. I would say, you mentioned TikTok as well. I'm not convinced that the U.S. government has the ability to actually ban TikTok. I think if this proceeds in the direction that it looks like it might, we may very well see this ending up at the Supreme Court as a speech freedom question, and we may get some very interesting answers, both about the freedom of people to choose a platform by which they speak, but also the freedom for people to express themselves algorithmically, meaning that the developers of TikTok created something that produces content, that arranges content in a certain way. How much is that expression protected, particularly when it's being done for commercial use? These are questions that we have kind of inclinations. We can look at what previous Supreme Courts have ruled on, but these are different times. These are different, jurists. I think we're going to see some really interesting stuff come out of the Supreme Court if it makes it there. Up top?
Yeah, I was wondering how the school is handling it when the students writing papers and stuff like that. Back in my day when I came here, I would sure let that have a little help.
Well, and that's a great question. So the question was how NDSU is dealing with AI as it relates to student work. And right now, I think at NDSU, like in a lot of places, we're relying kind of on foundational principles, right? That people should be doing their own work. I think there's a really big question of where the line between assistance and unauthorized aid is. That's something that there's a lot of opportunity to discuss further. Certainly students should have clear understanding of whether they're on the right side or the wrong side of that line. And that's something that is very challenging because technology continues to change. Even saying, well, it's okay to use something like Grammarly, but not okay to use something like, say, OpenAI's ChatGPT. That's something that can change dramatically. And again, I'm not saying that should be where the line is drawn. I would actually argue something very different. But my point here is that what happens if Grammarly suddenly introduces their own, let me help you write this module, right? Now suddenly we're saying, oh, well, Grammarly's fine, but now Grammarly is doing the same thing that the thing that we may have said was not fine is doing. So it's a very challenging question. I don't think there's a great answer to it, kind of across the whole educational ecosystem, but it's certainly something that needs to be resolved and needs to have better rules and better guidance than perhaps exist right now anywhere. So that's a great point as well. I think we're probably out of time here. Any last questions or? All right, yeah.
So back to what you answered to John, is you were talking about possibly that system couldn't be prosecuted or company couldn't be, because how could the system know what it was doing? And yet we're saying that AI is learning, so there is some knowledge involved. It also sort of takes into questions the concept of ignorance of the law is no excuse.
No, I mean, so those are a few different interesting points there. The system learning, who the responsible party is, even the very foundational concept that in at least most cases, ignorance of the law is not seen as an excuse to it. I think at this point we don't have a juristic framework for prosecuting a system. So I think we start with kind of a constraint that you're dealing with a user of the system, whether it's a human user or a juristic entity that would be responsible for its conduct. And then you get into the question of, well, where does it make the most sense to place that responsibility? And certainly, you have questions both in terms of whether whether any party was an intentional bad actor. Typically, if we have an intentional bad actor anywhere in a process, we tend to focus our penalties and efforts on that individual. When you have a lot of people or entities that are trying to be good actors and they're failing to do that, that's where it gets more challenging, where no one entity, no one person said, they were intending to violate a particular law. However, through the combination of those activities, of those people, of those entities, a law was nonetheless violated. But it becomes a very complicated question to figure out, who should be penalized, whether everybody should be penalized, how penalties should be apportioned amongst those that are responsible. And so I think that's a great question. I don't think there's a perfect answer to it. Certainly, I think there is a role for legislative bodies to help kind of try to answer that, to provide a framework for courts to use in terms of divvying up responsibility. And obviously, there's a lot that's left to the particulars of a situation and left to a court that's faced with that challenge, and certainly creates a very challenging environment for judges that have to suddenly understand how technology works and where the different components or interactions are of something that they may not fully understand, and then come up with a good decision based upon it. So that's another great question. Any last questions? All right, if not, thanks everybody.